Hi, everybody, and welcome to Raw Law. This is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney. And welcome, everybody. Thank you for being here. And let's get into it. This is the show where we answer your questions and we talk about your comments. And we're live. And let's get into it. Let's answer your questions. So the first question I see is from Marquita, and she asks, Publix repeatedly denies my claim, saying tripping over beer cases is my fault for getting up from an electric shopping cart. I had no choice because the aisle and coolers were blocked. Is this disability discrimination? Yeah, I mean, definitely make that argument at trial. Now, they don't have to, accept your claim and pay you. And even if they accept your claim, they could pay you less than you want, right? You might think your claim is worth $1 million, and they might say, you know what, your case is worth to us 10,000. Right? There's no law that says they have to just pay you what you want, but you are entitled to a jury trial. So if you don't like their offer, then go to a jury trial and you have to win. You have to show liability by using experts, by testifying, by having doctors, and you could definitely win the case. It sounds like a good case to me. And she also says that Publix would not be able to use the shopping cart argument against a non-disabled person who tripped and fell over an aisle obstruction. Right, that's a good point. So I would make that argument at trial, and I would have a jury that can empathize and be compassionate for someone with a disability, right? That it's going to really resound with that kind of a juror. So I would really do that. I would pick that kind of jury, and then I would make that argument, have your lawyer make that argument. And then Brandon says, hey, what's the purpose of a request for admission and request to produce? It's been 2 weeks since the defendant has been served, and my deposition is in May, 3 months from now. Is 3 months a reasonable time to schedule a deposition, 2 weeks after the defendant has been served? Yeah, I mean, I think so. Absolutely. A request for admission is usually you're requesting them to admit certain facts. So you put certain facts in the request. For example, if the car was, a Toyota, that it had this kind of license plate, and you put the license plate, that there was contact between the cars, and then they have to admit or deny certain facts. In New York, we call it a notice to admit, but in other places, it might be a request for admissions. And then a request to produce would be like documents that you're trying to get. So in a car crash case, it might be photos of the cars, the location where it happened, the property damage bill, whatever you think is relevant. In the trip and fall case, it might be inspection logs, photos of the unsafe condition, or if they had repaired it before, repair records, invoices, things like that, whatever you think is relevant, and that's what you would request. But yeah, a deposition usually comes after that, because if you don't have the documents, if you don't have the discovery, then you have to go and you have to take the deposition, right? But you don't have the documents. So you would ask more questions if you had the documents, so then you would have to then go and do the deposition again. It doesn't make sense. So that's why you want to get the documents first, like the requests for production, the requests for admission. So you're kind of narrowing the issues, and then you go ahead and you do the deposition of the defendant. And the plaintiff's deposition kind of works the same way. They'll want to get your medical records, whatever they're asking for, and then they'll question you about that. So then, because otherwise, if they got the medical records later, then they would have to question you a second time, and you don't want to give them 2 bites at the apple. And then Marquita also says, my SI joint fusion costs $120,000. My medical bills are now over $200,000, plus future care and lost wages. How much can I ask for in pain and suffering? Yeah, so I mean, you could ask for a large amount. Remember, pain and suffering doesn't have anything to do with medical bills. Those are just your costs, right? So if your SI joint fusion procedure costs $120,000, if that wasn't paid and you owe the $120,000, or you're going to need another one in the future, like even in 20 years, you can ask for the $120,000, but that's not your pain and suffering. That's your medical cost, which is an economic damage, right? There's like lost wages, the paycheck losses, there's future medical costs, like the cost of physical therapy, the cost of prescriptions, the cost of surgery. Those are all economic damages, right? Because they're certain and they're economic. But what we're talking about is your pain and suffering, like your grief, right? Your humiliation, your actual pain, the physical pain, the mental suffering, the loss of enjoyment of life, all those things fall under non-economic damages. So it depends on your state what's allowed and what are the categories. But you could, if you had an SI joint fusion, that's a pretty serious surgery. So for example, you could break it down however your lawyer likes to do it. Some lawyers, what they do is they go from the date of incident. If the date of incident was like 3 years ago, they'll say, well, for the past 3 years, she had this major surgery, other injuries. We want, for example, $500,000. And for the future, she's X years old, but people live to be like 83, 84. So she's got like 30, 40 more years of life. So for that, having to suffer, this isn't going to go away. This is a permanent, life-changing, forever injury. So for those 30 future years, it's worth another $1 million, right? So altogether, 1.5. The other way lawyers sometimes do it is they look at all of the years and they say, okay, 3 years past, 30 years future. So the damages period is 33 years. So for 33 years of pain, we're asking for $2 million, for example. Like, you could do it that way. But it's up to your lawyer. Okay, and then Ruben says, if my lawyer takes days and weeks to respond to my emails or calls, is that acceptable behavior from a lawyer that's representing you? Well, it depends what it's about. If it's some simple thing and he's just busy because he's in trial or court, it could be fine. It depends on if it's acceptable to you, right? It's like anything. It's like if you go to a restaurant, you go to a nice restaurant like white tablecloth and you expect a certain level of service. If you go to McDonald's, you expect a different level of service, right? So it's like, if you're happy with that lawyer and you're okay with that, if that's the way he operates, then it's really up to you. I can't tell you, if it's something really vital, like, you think you have a court hearing and the court hearing is like in a few days, but he's taking weeks to respond to you and you're going to miss the court hearing. Well, of course, that's not acceptable. You don't want to miss a court hearing. The case can get dismissed, right? So it's just depends on your preference and what the communication is about. And Naman McCoy is here. Hi, how are you? He's a member of our channel. We have this new thing where you could become a member, and I'll try to do some things for the members where they could contact me, maybe like have a consultation, or we could do some special videos where we answer their questions personally. I think that's a new thing that they're doing with our channel, allowing people to become members. And then Marquita says that she was scammed by a fake lawyer and who got arrested and stole thousands from her and prolonged medical care and claim pursuit. And can this be considered pain and suffering? Well, it wouldn't be pain and suffering for the case, right? Because the case is the trip and fall because of the boxes of the beer. So the pain and suffering from that. If it's a scam by a lawyer, that would be a different case. So I don't think you can, that's like what's known as an intervening cause, because, you didn't know it was going to be a fake lawyer. It could have been a real lawyer, right? That's like an intervening cause. You can't say that the fact that you got scammed by this lawyer who pretended to be a real lawyer was caused by the fall over the beer boxes, right? I don't think it would flow unless there's some kind of logical connection. Okay, and then Brandon also says, also, what's a notice of production from a non-party subpoena? And I really appreciate these lives you do. I learned so much. Thanks, I really appreciate it. Yeah, sure. So when you do a non-party subpoena, what you're usually doing is you are asking them either to give you documents. Like, for example, I know that a non-party has something, and it's just like what it sounds like, right? It's a non-party, so it's not a party to the case. So I subpoena them, and I ask them to bring the documents to either my office or to the courthouse. And it could also be a subpoena for a deposition. Like, I know someone, for example, a non-party might come. Like, for example, if I'm suing a building, okay, and I'm suing them for having a defective condition, like they have a hole in their steps. And then there's a non-party, a cleaning company, ABC Cleaning Company. They come and they clean those steps. So I might do a non-party subpoena to depose someone from ABC, the cleaner, to say, hey, when you come there and you clean, how long have you been cleaning? Oh, 10 years. Okay, all those 10 years you've been coming and cleaning. Do you see this hole in the step? They'll say, yes, I see that. Okay, now I have noticed, right, that it's been in existence for like 10 years. They should have found it. They should have fixed it. Why didn't they, right? And that's negligence on them. So that's one way. And then, so that's basically when you ask for, and if you're asking for production, you're asking them to produce something, documents usually, photos, documents, videos, could be surveillance, right? Could be whatever is in your case. And then a non-party subpoena could also be either for documents or it could be a deposition subpoena. And then Shawnee says, my mom passed away after her gallbladder removal surgery. She was leaking bile into her stomach. They placed an NG tube to drain her, but she got septic, I believe, from her suction machine malfunction. Oh, I'm so sorry to hear that. Yeah, that's terrible. But a case like that, what you'd want to do is get a local lawyer who does medical malpractice, have them obtain all the medical records, have them review it with an expert. They'll have a doctor. Usually lawyers that do medical malpractice have their own either nurse on staff or access to doctors, who will then review it and tell you whether those doctors who are their experts, your experts, find a case of medical neglect. And if it is a case of medical neglect, then you're allowed to then file a lawsuit and pursue that case against the hospital or the doctor. So that's usually how that works. And Marquita says, thank you, you're amazing. Oh, thank you so much. Yeah, let me know if you have any other questions, or feel free to text me. I'm happy to also do a consultation, like a private consultation. The number is 347-566-9595. And Benito says, what happens if the insurance does not respond to a demand letter? Yeah, so that happens a lot. I mean, the case continues. Nothing really happens. You're asking them to settle. You're giving them an amount that you would settle for. And for whatever reason, they don't respond. It could be because they're busy and they're handling hundreds of files and they just haven't gotten to it yet. It could be that they don't think your amount is reasonable, like you're asking for too much in their mind, or they're just not authorized to pay. It could be, 1,000 different things. It could be, according to their procedures, they're just not willing to pay because their procedures require them to go to the supervisor and then get another level of authority and another level of authority for the amount that you're seeking, and they just haven't gotten there. So it could be a lot of different things. But the case just continues. Nothing really happens to the case. The case is still active. And then Sasha says, hi, Arkady, what would be a reason a lawyer deposes a witness twice in a personal injury case? Yeah, sure. So that would be, for example, if you depose, for example, the plaintiff, right? And you've gotten all their information, but then they go and they have, let's say, surgery. Let's say the plaintiff has surgery. Well, now you haven't questioned them about the surgery because you didn't know. They didn't have it back then, right? This is something new. So that would be one of the reasons. So then you would get another deposition about that surgery. So usually if it's something new or something unanticipated or unusual that happens, it can happen with the defendant too. If you're questioning a defendant, and then they're telling you something, but then, for example, they didn't turn over some vital documents, and then you say, hey, I want another deposition. Usually with a defendant, you can ask for a deposition of someone else, but sometimes I guess it could be the same person that you end up deposing. Just move my screen so it's more centered. We actually shot some videos. We had the videographer here today, and we shot some videos. We actually did a trial analysis video, a very interesting one, about an actual trial that happened, and we had some of the footage on Courtroom View Network, and we did like a trial analysis. So he just left, so we were doing some videos. So my screen was like over to the side. Okay, let's see. Stephen asks, what can happen if the defendant doesn't answer a lawsuit by the date required? So then you would move for a default judgment, because if they don't appear and they don't answer, they're in default. And then you move for a default judgment, you get a judgment because they haven't answered. And then Life with Val says, do you know what's the next after the defendant sends over the list of questions to the plaintiff in a lawsuit? Yeah, sure. So usually the list of questions, I think you're talking about, if you're in New York, you're talking about a bill of particulars. So when you file a lawsuit, you file the summons and verified complaint. They answer, they appear in the case. They usually deny everything, or they deny that they have knowledge or information. And then at that point, you'll want to have a preliminary conference with the judge. But before the preliminary conference, with their appearance and answer, they'll serve you with a demand for bill of particulars, like what's your name, what did we do wrong, what's our negligence, what are your injuries, and you have to answer all those questions. And then after that, you'll have the preliminary conference with the judge, and then at that point, you'll have depositions, like deposition of plaintiff, deposition of defendant. So that's pretty much the start of the case. That's how the case starts. And let me see. Sasha S says, thank you. Oh, you're very welcome. And Life with Val says, yes, that's it. Thank you. Oh yeah, you're very welcome. So that's good. If you're doing the bill of particulars now, cooperate with your lawyer, answer the questions, and then once you do that, you're going to have a preliminary conference where the judge gives you like a schedule of everything, on the additional documents to turn over from both sides, depositions, and then you'll put it on the trial calendar once you're all done. And JRM says, what's a reasonable settlement in Queens, New York for a re-injury of a rotator cuff in a trip and fall at a rental unit? Had surgery in 2017 and 2018. The incident has impacted me in a big way, such as lifting. Yeah, so I mean, in order for me to tell you, it's probably best to text me because, see, if you had an injury before, you can definitely still sue to the extent that that injury that you already had was made worse by this incident, right? By this case. But in Queens County is pretty much not bad. It's very mixed. You have a lot of different communities, Asian, Spanish, different communities in Queens. So it's okay. You just have to pick the right jury, litigate the case aggressively. So the real question would be, what is the re-injury, right? Like, what did you have before? How were you before this incident? And to what extent did this incident make whatever you had, your condition, worse, right? That's going to be what you get the money for. So if you had, for example, a shoulder scope in 2017 or 2018, and it was healed and you were fine and you were like throwing baseballs and you were normal, and then because of this incident, when you had this fall, now you need another shoulder, I think it's pretty much almost the full value of a shoulder surgery because you were okay, you were better, you weren't hurt, and now you are, right? Now you need a shoulder scope. So I would say that could be like $300,000. It could be more. It just depends on the actual injury. We'd have to do a deeper dive. And then Marquita says, my lawyer said she plans to ask the court to pay for my case filing for my financial hardship, but isn't she supposed to pay for it? This will prolong my process. For the case filing? I mean, yeah, usually lawyers just pay for that. It's not expensive. It's like $200 usually. I don't know if she means she wants to do it for free under some kind of financial hardship. I don't know if, how long that takes in your state. You would have to ask your lawyer or someone else in that state. Usually those things shouldn't take long, but she could try. If it takes a day or two, if they give it to you, then do it under the hardship. If they don't give it to you, then she would have to pay for it. She'd have to front the money, and then later when she settles the case, she takes the money back. That's how it works. And then Mo says, hi, Arkady. The judge granted my summary judgment motion. Is it a good thing for the case, and how is it affecting the settlement process? Yeah, so if you filed a summary judgment motion and the judge granted it, that's good because, if you're moving for summary judgment, that means there's no question of fact for a jury to decide. Everything is so clear. There's prima facie evidence of negligence. For example, if you're stopped at a red light and a car rear ends you, well, there's no question that you did anything wrong. You're stopped at a red light like you should be, and this crazy guy rear ends you, so it's their fault. You get a judgment as a matter of law. That's a summary judgment. And then what happens is later on, you still have a trial as to damages. And if the jury says, okay, your damages are $100,000, well, now you get the $100,000, but you can also, at least in New York, go back to the date that the summary judgment was granted. That could be like 2-3 years earlier. And for all those years, you get 9% interest each year on the 100,000. So it'll be increased, so it's a good thing. It actually gets the defendants to settle because they don't want to pay you what your case is worth. And then on top of that, have to pay 9% interest. So because of that, they sometimes just say, you know what, let's settle once you get summary judgment. So I always do that too. I always move for summary judgment on cases where I have strong liability. Yeah, absolutely. That's a good thing to do. Yeah, let me see. So we have any other questions? Happy to answer one or two more questions. We've been here for about 20 minutes. We could do a little longer. We could do 30 minutes. We could do, sometimes these go for like an hour. I'm pretty much okay, depending on you guys, depending on everybody and what questions you have. Yeah, I think some of these cases that you're mentioning are, interesting cases. like the public's case should be a good case. It sounds like that venue might be a little tough, right? That Alabama, from what I remember. So yeah, you can feel free to text me. We could do a private chat about that. I'm happy to help. What I've been doing, sometimes people in New York, when they text me, they give me their name, and then I could look up the public court filing, because it's public, right? There's the New York State civil electronic filing. There's also e-law. And then I could see what's in there, and I could give you some input, so people get a lot more input as to what's actually happening. What I could also do is I could look up the attorney if you have questions about the attorney, and send you their settlements, their verdicts, because I have access to the databases like Lexis, Westlaw, and Verdict Search. So that's been helpful for people. And in other states, sometimes people just have lawyers that, like, for example, never call them back. They can't reach anyone. Every time they call, they speak to a one of those case managers, but they don't really know anything. They're like a bad secretary. So you hired a lawyer, you didn't hire a bad secretary. So what I do is I then help them and maybe find like a real trial lawyer in that city, and then they get someone else, and that's better for them. So I've been doing that for people like California, Texas, Florida, Michigan, all over. And it could be anywhere. So I have access to find out who's the best lawyer in each area. And then Marquita says, thank you. Sorry, I have so many questions. My lawyer is not helpful. She only says everything will be fine, but offers no details. Yeah, I know that can be frustrating when you have a case and you want to have a consultation, but people don't really answer your questions. And then Mo says, and how long do you think after the summary judgment is granted, the settlement can be reached? Yeah, so I mean, it could be quickly. It could be even a week or two. It depends on the case, right? It depends on the injuries, depends on the everything, depends on how much you're asking for, right? So if it's like a limited policy, if it's, let's say, 100,000 policy, you get summary judgment on liability, they might just tender the 100, give you everything. If it's bigger, if you're looking for like millions, they're not going to be giving away their money so easily. Then it might be a little bit more of a fight, to be honest. Usually when the numbers are higher, that's when you have to fight a little bit. And then Oliver says, I've reached out about having the proper attorney for my case, just haven't had a response yet. Oh yeah, no, if I didn't respond, just text me again. It's 347-566-9595. I've been busy a bit. I've been working on some motions, and I've had some court appearances and stuff like that, depositions. So I haven't, had time to always respond to everything, but I've done some consults. I even did a few this weekend, like on Sunday, I think I did a few before the Super Bowl. So I'm trying to, do as many as I can. So I'll definitely get back to you. And then Sasha says, why would a lawyer continue to pursue an unwinnable case? Well, I mean, if it's unwinnable, if the lawyer thinks it's unwinnable, then they're not going to pursue it usually. Or if it just depends, right? I mean, they probably don't think it's unwinnable if they're pursuing it. If they're pursuing it, they probably think that they're going to win, right? I don't know if you mean the plaintiff's attorney who's pursuing the case on behalf of the injury victim and trying to get money, or do you mean like the defendant? Like, if you're talking about the defendant, then they might want to keep pursuing it even though it's unwinnable for them. Like, you're going to win, right? Because you have such a slam dunk liability, you have serious injuries. But what they're going to do is they're going to try to delay everything, right? And then try to pay you less. So if full value is, let's say, $1 million, they want to delay, and they want to pay not $1 million, but they want to pay maybe like $50,000, $100,000, maybe $200,000, anything they could save. That's what they like to do. They like to save their money. And Benito says, why are herniated discs worth a lot if you get surgery? Yeah, I mean, herniated discs, they're worth a considerable amount because it's painful, right? You have these discs and you have vertebrae in your spinal column. It's your spine. And essentially, the vertebrae are the bone, but the discs are the cushions between the bone, and that allows you to bend. So if the disc gets herniated, it just means the disc is exploded, and inside the disc you have this jelly, and now the jelly's leaking out. And the jelly's not supposed to be outside the disc. It's like a liquid. Imagine the liquid kind of leaking outside the disc, and now it's touching all the nerves, because you have these nerves that are running from your neck down to your hands, right? From your lower back down to your legs, all over. So those get impacted, and if the nerves get touched, you're feeling pain, and you lose your ability to move. That's known as radiating pain or radiculopathy. So then if you end up getting surgery, like a fusion, what they're doing is they're removing the disc, they're putting in an artificial disc, they're taking bone graft from your hip, they're putting screws into the vertebrae, into the bone, and they're adding a plate to like stabilize everything. Now you've lost mobility permanently. And if you have it at one level, let's say like C3, C4, then you're going to need it at the adjacent level, like C2, C3, as well as C5, C6, because you had it at C3, C4, right? So now you're going to need it at the level above, level below. Each time you do a surgery like that, first of all, the surgery costs like about $100,000. But then what about having a permanent, life-changing injury? You lose mobility, you have a plate, you have screws, the hardware could break, you might need a revision surgery. So that's why it's worth a lot, because it's just a serious injury. So it could be worth, like, if you don't have the fusion, if you have the percutaneous discectomy, I've seen cases go for, $500,000, $300,000. If you have the fusion, usually $1 million, $2 million, it could be even more than that. And Sasha says, how much is an occipital condyle fracture worth? Well, I mean, I wouldn't be able to tell you something like that, because they're all going to be worth different depending on where you are, depending on what happened. So it's not just like injuries in and of themselves don't necessarily have value. It's really like the whole case. We'd have to look at all the factors. But a condyle fracture, I mean, a fracture is usually has going to be something in the six figures at least. Usually, maybe high five figures, meaning like the lowest people would get for fractures is like 75,000, right? And then usually much more, hundreds of thousands usually. But I could do a search. I could do a verdict search if you tell me like what city and everything. I'm happy to do a verdict search and let you know what those go for. And then Brandon says, I was rear-ended. I was in traffic, slowing up for traffic in front of me. Then I was rear-ended. I'm in Tampa, and I'm not at fault. Yeah, that sounds like a good case. I mean, that sounds like a summary judgment case, too. And the next says, at one point in a case, the attorney finds out if the defendant has insurance. So usually fairly early, right? You could send a letter and find out before you even file a lawsuit, and they'll just tell you, hey, our insurance is X. Or if your state doesn't allow for that, like New York, we can find that out. But some states like New Jersey, they don't tell you. Then once you file a lawsuit, they have to tell you at that same preliminary conference we were just talking about. So at that conference, you just say, hey, I need to know all the insurance. And they tell you all the primary, excess, umbrella, all the insurance limits. You're entitled to that. And then C. Hampton says, hi, why would my attorney keep rescheduling the workers' comp hearing case? Happened 3 times the day before the hearing. Broken bones, concussion. Yeah, that's hard for me to say. I don't really do workers' comp, so I'm not sure. But if he's the one rescheduling it, maybe he doesn't have all the evidence. It's just a guess. Because usually if you have all the evidence and whatever the purpose of the hearing is, I believe these hearings, a lot of the time, the lawyer wants to get, everything kind of like approved or get authorization. So it could be that the lawyer's trying to get authorization for a surgery or authorization for a medical procedure or approval to get that you are a worker, that you were injured at work, right? That those are usually the issues. That it has to be work related. It has to be in the course and scope of employment. And then also that, it happened while you were working, and then that you would start getting lost wages, checks for your paycheck losses, for your lost earnings, as well as get your medical bills paid, send money to the doctors that are treating you and get everything approved and authorized. So maybe he doesn't have the evidence to do something like that, but that's just a guess. But you could just ask him, he should tell you. And then Mass asks, hi, my personal car injury is now in 15 months. Insurer still has not offered us anything. Is that normal? I have PTSD, chronic back pain, and major depression. Yeah, I mean, unfortunately, sometimes the insurance companies never offer anything, right? That's the whole big point that I keep talking about in a lot of my videos, that people think insurance companies are supposed to be fair because they take your money, rather not your money, but they take the policyholder's money, right? Like if I need car insurance and I go to like State Farm or Geico or Allstate, I'm going to give them money, whatever it is, like $500 every few months, and whatever people pay, like $2,000 a year if you have like a car, or it could be more, $3,000 a year, whatever it is, right? You're giving them money for premiums, So then if something happens, if then I go out and I hit someone by accident, because I'm like, get a ping on my phone, I look at my phone for a second, I hit somebody by accident, I didn't mean to, I heard someone, they need surgery, they're suing me, I would tell my insurance, well, pay them, pay them, I have a whatever, 250 policy, pay them 250. But the insurance company just doesn't, because they don't want to be fair. They want to save their money. They want to keep the 250. They want to pay the guy 50 or zero, maybe get the case dismissed. So that's why. So it's not, you just have to understand that. Like a lot of the times that comes up as a recurring theme over and over again. People think, well, why is insurance not fair? And it's just true. They're just not, unfortunately, they're just not fair a lot of the time. And then Alex asks, how long does it take to get a preliminary conference? Yeah, so for a preliminary conference, usually it doesn't take too long. Usually it just takes about, maybe it should be really like a few weeks, but sometimes some courts are backed up for whatever reason after COVID. Like for example, in New York County, which is Manhattan, people have been waiting like 5 months or 8 months for a preliminary conference. And I guess they have to fix that. But usually it's not too bad. Usually like maybe a few weeks, few months at most. Shouldn't be like 8-month waits, and you're losing like a year in the case. Nothing's happening. So that's really not proper. But unfortunately, I have seen that happen. Yeah, so let's see if we get any other questions. We got some good questions today. Some really good questions. Yeah, thank you for joining, for asking these questions, and for for interacting. Yeah, let me leave you my number too. If you have any questions, you could text me. I'll text me, and I could do a consult. The only thing I ask is when you text me, if you could text me like your name, facts of what happened, so I could almost like see what happened. It doesn't have to be long. It could be like one sentence. Like for example, I got rear-ended, or I tripped and fell because of a hole. And then text me the date of incident, text me your city, text me your injuries. You don't have to put like some people put like I have a C3, C4 herniation with impingement. You don't have to put like from the MRI. You could just say I have herniated discs, like something like, or I have a tear in my knee, or just really brief. And then that's about it, right? Once I have that, like the liability, what happened, the injury, what city you're in, then I could schedule a call with you, and we could do a call, and we could do a deeper dive into everything, and then hopefully I can give you some positive feedback or some guidance so you can get some value from the consultation. And Sasha says, thank you for educating us. Oh, thank you. Thank you for being here. I really appreciate it. Absolutely. I'm happy to help. That's what it's all about. Our goal is helping serious injury victims and families, so we're really glad that we're able to help. Okay, and Jeannie asks, how long on average does it take for the plaintiff to schedule a deposition date after everything has been exchanged? Yeah, so usually the plaintiff doesn't have to schedule the deposition, at least in New York. The way it works is once everything has been exchanged, like for example, like we were talking about earlier, so you file the lawsuit, they appear, they answer the lawsuit, they say, you say, you hurt me, basically. They say, no, we didn't. They deny everything, right? So then they ask you questions like, what did we do wrong? What are your injuries? So you answer their questions, whether it's interrogatories or in New York, they're called bill of particulars. Doesn't matter, right? It's just different names for the same thing. So you answer their questions, you give them discovery, documents. At that point, you ask for a preliminary conference. So then if the preliminary conference is scheduled, you go to court and you have a judge sitting there, and then at the conference, the judge tells you, okay, you have to, any other discovery documents by X date, depositions by Y date. So you have a court order. So then usually from when you go to the conference, the depositions might be a few months after that. So it's not like you have to ask for it or you have to schedule it. The court schedules it for you. And then it'll be right in the order. If it doesn't go, then it's a violation of a court order. So then what you do is you make a motion and you say, look, they didn't go to the deposition. They violated the court order, like, preclude them from testifying or, force them to testify, and then the court will just force them to come. So that's usually how it works. So yeah, and then let me see. C. Hampton says, do you give referrals for workers' comp attorneys in Nevada? Yeah, I mean, I can. Like, I don't really do workers' comp, but I could ask around. I know a bunch of lawyers in Nevada, really good trial attorneys, especially for like personal injury. So I could ask if they know a good workers' comp lawyer. I'd be happy to help with that. And Saren says, Trial by Human, is that your merch? Oh, no, that's not mine. That's one of the groups I'm in, Trial by Human. So they're a group, and they teach trial skills like jury selection and human story, like biographies that I talk about. So I learned a lot from them. They're great guys. We're partner on some cases together. We partnered on a few cases. We may be doing some cases together soon that I'm looking forward to. And they were actually on trial. Some of the lawyers from that group were on trial. And that was the trial that I watched some of the trial, and I did a trial analysis of it. Because, we talk a lot about trials, right? Jury verdicts, but this was the actual trial. So I just watched some of the opening, some of the doctors, some of the lay witnesses, some of the closing, and then I commented on it, and we did some videos. We shot that today, so that should be coming out over the next few weeks. I'm looking forward to that. And then Baby Boy says, can you do an Atlantic County search for settlements in New Jersey? Yeah, I could. Atlantic County, New Jersey. Yeah, just tell me the injuries and the type of case. Like, for example, is it a truck accident, car accident, and a little bit about the injuries? You can text me. I'll be happy to do it. Or I could even do it. Like, I think we had another one, right, when I was doing it live. So I could even do another one. Maybe I'll try to do it. Maybe not tomorrow. I won't be available tomorrow, but maybe like Thursday I could do another one of these like lives where I do verdicts, and I could do it live, but you have to tell me like the injury, like for example, torn shoulder, herniated disc, fusion, whatever it is, and then the county you're in, and I could do some of the verdicts, and I could read some of the information to you live. I'm happy to do that. And Jeannie says, oh, for scheduling a deposition, you're in New Jersey. Okay, so New Jersey, maybe, I'm not familiar with New Jersey. It may be different, but I think actually New Jersey is probably faster than New York. So you get it scheduled pretty quickly because New Jersey is more efficient. It's a little smaller than, New York is so big. So it's more efficient, it's faster. And Marquita says, I was sexually assaulted by my Uber driver on my way home from physical therapy. Is that relevant to my pain and suffering? No, well, that would be a separate case. There are actually lawsuits against Uber for that, for drivers doing the sexual, that happens. I'm sorry to hear that. You'd have to, that's a different case. So that wouldn't be pain and suffering for the trip and fall over the boxes, right? Or the beer. That's a different case. But yeah, you could sue for that too. Those are good cases. And My Life says, I live in New Haven, Connecticut. I'm looking for a lawyer for an injury. I will text you. Yeah, sure, absolutely. I'm happy to help. I know some good lawyers in Connecticut, depending on the type of case. Actually, one of the big lawyers from Las Vegas who was getting like crazy verdicts, like he got a verdict like $400 million. He has another office that he opened in Connecticut, partnering with some lawyers that I know in Connecticut. So, and I'm friendly with some of the lawyers there, and I actually had lunch with them a few weeks ago. So maybe them, but they only do like really big cases. So I don't know if you have a really big case, but if not, there's other lawyers that are good in Connecticut. So I know a lot of excellent lawyers out there. Oh, for a slip and fall. Okay, yeah, for a slip and fall, I'd be happy to help. Depending on what the injuries are, maybe they would do it, or if not them, then we could find someone else. But we always try to get the best possible lawyer for you. So don't worry, you'll be in good hands. Okay, so let's see if we have. Oh, we're almost at 40 minutes. If we have any more questions, I'll answer a few more. If not, I guess we could wrap it up a little early. Sometimes we go for about an hour. Sometimes we go a little less, like 30 minutes, 40 minutes. Just depending on the day. Today is supposed to snow, so maybe people are trying to get home to avoid the snow. I don't know, it's supposed to snow, I think, in New York today. So we'll see. Let's see what's going on. Yeah, see, I got a few texts actually while the live was going on. People texted me, so I'll get back to you. Thank you for reaching out. Okay, yeah, I'll give it another minute or two, see if there's any questions. If not, then we could end a little early. I'll start the drive home so we don't get stuck in the snowstorm. But yeah, I mean, yeah, but take a look at that video that I was talking about, the one about the trial. I think it's interesting because the case was about a fusion, but it was also a brain injury. And it was like a truck hitting a car in the rear, kind of like not a light impact, but not a huge impact either. So kind of like had some issues. And I thought the defense did a good job, you know, so it was a tough case, but, you know, and you could see all the arguments that are typically made on the plaintiff's side and on the defense side. And C. Hampton says, may I have the referral for the Las Vegas attorney? Yeah, absolutely. Just text me. You know, I don't do the referrals publicly. It depends on the type of case and everything. So if you text me, like I was saying, like your name, brief facts of what happened, just look one sentence, how you got hurt, your injuries, and then your city. Yeah, absolutely. I'll text you the attorney. If it's a workers' comp attorney, I have a workers' comp attorney. If it's a third party, personal injury, I have those as well. So whatever you need. Okay, everyone, thank you for being here. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. Let us know how we could help you. If you have a question, just text me, 347-566-9595. And we'll do another one later this week. We'll try to do one on Thursday around the same time, maybe like 4:45 or 5 p.m., maybe 5 p.m. on Thursday. Okay, everyone, have a great night. Bye-bye.